So now to matters of presidential petitions. The Kenyan presidential election is back in court after at least two petitions challenging the October 26th election of President Uhuru Kenyatta have been filed at the Supreme Court by yesterday midnight. Let's now link up with our reporter, Sophia Wanuna, for an update on what happened yesterday night. She is joining us by way of phone. Sophia, very good afternoon to you. Kindly, let's just go through the number of petitions that have been filed last night and what the prayers are.
Good afternoon, Akisa. So 3 petitions were filed yesterday. One of the petitions that was filed was by Harun Mwau, and that is around the question of the nominations, because he continues to argue, as we saw as he moved to the High Court earlier, that this 26th repeat election should not have happened, without nominations. That is due process, and the IEBC did not comply strictly to the rule of law, the requirements, applicable law in conduct of elections, and what the Constitution stipulates. So that is the Mwau matter. And he raises even the question of the manner in which the IEBC went about gazetting the candidates, because remember there was a lot of changes and amendments. Initially they only gazetted 2 candidates, Odinga and Kenyatta. Then they included all the candidates, then expunged the name of Cyrus Jirongo owing to bankruptcy issues. Then his name was reinstated again, Akisa. This after there was an order showing that that matter had not been fully canvassed. So that is one Supreme Court presidential election petition by Harun Mwau, but its basis and backbone is on nomination. Then the other one, Akisa, is by the Institute of Democratic Governance, and this is through Kioko Kilukumi law firm. This is a different one. It's not challenging the election of President Kenyatta. In fact, it is seeking to find that Raila Odinga, Kalonzo Musyoka, Moses Wetangula, Musalia Mudavadi, and James Orengo, being the 5 respondents, committed electoral offences and malpractices, and that in so doing, this petitioner argues they infringed on the rights of citizens. Akisa, this petitioner also wants these 5 individuals to be found to be unfit to hold public office, and also to be found liable for all the losses that were incurred in the destruction of property during that electioneering cycle. That's the second petition, Akisa. The third one was filed last evening by Helef Khalifa as well as Njonjo Mue. And in this particular petition, the respondents are 4. That's the IBC chair, the IBC itself, Uhuru Kenyatta, and the National Super Alliance. They have several requests and prayers they're making before the Supreme Court. They want, of course, for the election to be invalidated. That's what they're arguing, that it was not conducted in accordance to the law. But one of the prayers they make early on is that by the time this petition is received by the Supreme Court, orders should be made to the petitioner to provide to the Supreme Court all the statutory forms that were used in the election, the 34s A, forms 34A, B, and C. And also, Akisa, they're asking for the 32A. Remember, that's the form that if a voter goes and is not identified biometrically using the KIMS kit, so their data is not captured there, they then fill the form 32As. And that's what usually will give you a full picture of the voter turnout. So they want all of this material, the SD cards, all the KIMS kits, even the report that was done over the voters register, the unredacted version, to all be submitted to the Supreme Court. They also raised the question of nomination, saying the same should have taken place at Kesa. However, in their prayers, there is no prayer being made against National Super Alliance, but they have been enjoined as respondents at Kesa.
Oh, then after the filing, Sophia, what do we expect to happen in the next few days?
So they have filed, that was the deadline yesterday, midnight it expired. So the next 2 days, it is to be able to serve the respondents. So Harun Mwau, this IGD organization, as well as Njonjo Mue and Helef Khalifa, will have to submit, or rather serve the respondents, so the various respondents. However, remember, there's always a soft copy version of it. So by now, all the respondents at least have a real look at what the matters raised against them are, but in 2 days, they must file everything. Then after 2 days, the respondents then have 2 days to return the same to the petitioners. So the next 2 days is being able to serve respondents, and then the respondents get to serve the petitioner back. After that, Akisa, what you are going to have is the filing of electoral applications. That is those who want to be enjoined as interested parties. You also have the amicus curiae when who may want to join as such, or any other application. Like last time we saw applications to be able to conduct those scrutiny exercises of the documents, and even looking into the server. So any application, they call them interlocutory applications, can be made in that time. After that, KISA, then we'll have a pre-trial conference. And the pre-trial conference is where, in essence, the issues are agreed on that will come before court for determination. What we're likely to see in this case, KISA, is that most of these petitions, in a sense, will be consolidated, because we cannot have hearing of one, then another, then another. We only have 14 days timeline, and it's a strict one because hearing probably be 2 or 3 days. So they must consolidate. All the parties sitting together agree these are the key issues. Failure to agree, the judges usually do that on their behalf, like we witnessed in the last election. Akisa.
Senior